Okay, good morning, everybody, and thank you for joining us today on our webinar in relation to the Housing Scotland Bill. There's quite a lot on the Housing Scotland Bill, and this particular webinar is an overview for the social housing sector. Couple of things to say about the bill and the webinar this morning. There's quite a lot that we're going to be going through this morning, so please bear with me. It's quite a dense subject. Also, apologies that I've woken up with a bit of a croaky voice, and so hopefully my voice holds out till the end as well. So please bear with me with that too. So just for those that have joined us in the last minute or so, this is a webinar just to cover an overview of the Housing Scotland Bill, and in particular, an overview for the social housing sector. So as I mentioned, there's a lot to get to, so we'll just crack on. So just to introduce myself, my name is Fiona McLeod. I am a legal director and solicitor advocate, and I sit within our public sector team at Brodie's. And I have a particular expertise in housing law. And what we're going to talk about today is we're going to have a talk about the Housing Scotland Bill. We're going to look at very briefly on rent control areas, but with a particular focus on the obligations that are going to be placed on local authorities in relation to rent control areas. We're going to look at delays to evictions and the provisions in relation to that, tenants' rights, and also the ask and act duty, which relates to homelessness. So, the Housing Scotland Bill, what's the current position with it? Well, it was introduced in 26th of March 2024, and it sets out plans to make changes to the existing housing law on quite a range of matters, and that includes rent controls, tenants' rights, the rights to keep pets, to decorate their homes. It also includes provisions to the changes for service of notices for social landlords, and that's something that came up as a result of the cost of living legislation, and also a mechanism to delay evictions under certain circumstances, and the ask and act duty in relation to homelessness that I just mentioned. The legislation is as currently drafted, proposes to implement many of the measures that the Scottish Government included in its New Deal for Tenants, which was originally drafted in 2021, and it forms part of the Housing to 2040 strategy. So, what's the progress of the bill? Where's it at the moment? So, as I mentioned, it was introduced in March of this year, and the calls for views were in place until the 17th of May. The bill is currently in stage one, and at that stage, what happens is the bill is given to a lead committee, and this is usually the committee whose remit most closely relates to the subject of the bill. The lead committee for this bill is the Local Government Housing and Planning Committee, and the lead committee firstly considers the bill, and then reports on it. Other committees also can examine the bill, and they will report into the lead committee, and then there will be a debate and a vote by all MSPs on the general principles of the bill. If the general principles of the bill are not agreed to, then the bill fails and it can't become law. Stage one is due to be completed by the 29th of November this year, so just at the end of this month. Stage two is period for amendments, and on the 31st of October, the Minister for Housing, Paul McLennan, made a statement and answered some questions on the bill. A particular issue that those of you that are working within the sector will be aware of is the concerns around the rent control areas and how those rent controls are going to be calculated under the bill. So the statement from Paul McLennan on the 31st of October set out that having considered how best to formulate the cap, the government's going to bring forward an amendment at stage two that's going to explicitly set out where rent control areas are designated, that the cap would apply to rent increases while the rent control is in force and set at a level of CPI plus 1% up to a maximum increase of 6%. And what does that mean? Well, that means that where a rent control area is in place, then in most cases, the rent will be able to be increased by CPI plus 1% of the existing rent. Where the relevant CPI figures exceeds 5%, then the increase permitted would be capped at 6% of the existing rate. And the rent cap will apply to rent increases both during the term of the tenancy and in between tenancies in the period where an area is designated for rent control. I don't intend to go into much more detail in relation to the the particular provisions around the calculations for rent control for private sectors in this webinar, but it's something that we may pick up in the webinar series that we will be doing in the new year. So if we just flick on to rent control areas, just with a brief overview of what they are and the obligations that are placed, as I mentioned, on the local authorities and focus on that for this particular session. So part one of the bill creates powers for the introduction of longer term rent controls for the private rented sector. And the Scottish Government policy statement behind this is that it was committed to delivering tenure neutral outcomes. And part of achieving those aims, the improvements set out in the bill contributes to delivering fair and a well-regulated sector, balancing the needs of the tenants and responsible landlords. If we just move on to the next slide. So prior to the introduction of the cost of living legislation, so not this housing bill, but the cost of living tenant protection legislation that came in, private sector landlords were able to set the level of rent increases within market rate. And under the 2016 Act, the landlord, which is the relevant legislation for private tenancies, the landlord can only increase rent for an existing tenant once every 12 months, and they must give 3 months notice before any increase can be applied to the rent. And the landlords, importantly, could reset the rent levels in between tenancies. Tenants had the right to refer any proposed rent increase to a rent officer for determination, and while the determination was being made, taking account of open market rent for similar rented properties in the same area. Currently, under the 2016 Act, local authorities can choose to make an application to the Scottish Ministers requesting that all or part of the local authority's area is designated as a rent pressure zone, where rent increases would be capped. And the Scottish Ministers can, in terms of the currently drafted legislation, so the 2016 Act, designate all or part of a local authority as part of a rent pressure zone. And that's where the rent increases have to be limited in accordance with a specified formula. There are concerns around data for all of that, and also there are concerns that the rent pressure zones just weren't being well utilised in the 2016 Act. So the new housing bill proposes to place an obligation on each local authority to carry out assessments of rent conditions in its area relating to the level of rent and the rate of rent increases under private residential tenancies or assured tenancies in properties in its area. And following this assessment, the local authority has to submit a report and recommendations to the Scottish Ministers by the end of the reporting period. And the local authorities have to have regard to any guidance that's been issued by the Scottish Ministers when carrying out the assessments of rent conditions. The first report is required by November 2026, and the reporting period is every 5 years. A local authority can also carry out an interim assessment of rent conditions in its area where it considers that there has been a significant change in the levels of rent or rate of increase in rents. And after carrying out an interim assessment, the local authority will then have to submit an additional report relating to the interim assessment to the Scottish Ministers as soon as possible. And where the local authority has been directed to carry out the assessment by the Scottish Ministers, it will have to produce the report within the timescales as directed by them. So just moving on to the next slide and the next sections within the Act. Local authorities' report has to set out the details of the assessment carried out, regardless of whether the local authority recommends that all or part of its area should become a rent control area. And where a local authority recommends that an area is designated as a rent control area, it must set out the reasons for making the recommendation and include in its report a plan of the area identifying the boundaries. So it has to make it clear what area is going to be affected by proposed rent control areas. And before designating an area as a rent control area, which is done by way of regulation, the Scottish Ministers have to consult with the local authority and also persons who appear to the Scottish Ministers to represent the interests of landlords and tenants in the area. When they're consulting on the proposed rent control area, there needs to be an 8-week period for representations to be made in response to the consultation. Local authorities can only recommend that an area should become a rent control area if it is if it is of the opinion that the measures to control the amount of rent increases under PRTs of properties in the area is necessary to protect the social and economic interests of tenants within the area. So that's the test that local authorities will have to apply. Scottish ministers have to then prepare and publish a report stating their decision to make an area a rent control area and their reasons for doing so. And the Scottish ministers must publish the report as soon as reasonably practical after receipt of the relevant local authority report and publish the report in an appropriate manner. And Scottish ministers may only designate an area as a rent control area if they are satisfied that restricting of the rate of increase in rent payable under private residential tenancies of properties is both necessary and proportionate. The bill also provides that there are certain properties that could be considered exempt properties, but those will be defined by future regulations, so we don't know what that is going to look like at the moment, and it will probably become clear what direction of travel that will take when we get into the stage 2 amendment of the bill. So just moving on to the next slide, please. So, as I mentioned, the Housing Minister produced a statement suggesting a proposed amendment for the government at the end of last month. So, so matters are still pretty fluid, and the suggestion is that the rent increases will be capped at CPI plus 1. However, in terms of the Section 9 of the bill as currently drafted, any regulations designating an area as a rent control area has to specify that the rent payable under the private residential tenancy may not be increased by more than a specified amount in the regulations which are to follow. So you'll see that there's becomes quite a theme that you have the primary bill, which will be the legislation, and that was going to be supplemented by secondary legislation to provide a little more of the kind of nuts and bolts of how it will work in practice. The bill also provides that the rent rises will be capped both during and in between tenancies, and the rent can't be increased by any more than once in a 12-month period, with no rent increase being allowed to take place in the first year of the lease. So just moving on to the next slide, please, Danny. Thank you. So what about monitoring these designated areas? Well, Scottish ministers have a duty to keep the operation of any regulations imposing rent control areas under constant review. Where they consider that a rent control measure with any rent control area is no longer necessary or proportionate, then they must, as soon as possible, vary or revoke the regulations as they consider appropriate, and that will either amend the area that is subject to rent control or alternatively remove the requirement for the area to be under rent control measures. Similarly, the bill gives Scottish ministers the ability to propose amendments to any rent control measures that apply to an existing rent control area, but before they can do so, the ministers must consult with the local authority where the existing rent control area is situated, and persons who appear to them to represent the interests of tenants and landlords under the relevant tenancies and properties in the existing rent control area. And again, they have to provide a period of 8 weeks for that consultation process. And if the area is not the regulations providing that the area as a rent control area is not revoked within a 5-year period, it will be revoked after that 5-year period. So it can only be in place for a period of 5 years. So coming towards the end of rent control areas, if we look at the frequency of rent increases, Section 19 of the 2016 Act provides that the rent payable under a PRT be not be increased any more than once in a 12-month period, as I mentioned. Section 21 of the bill also modifies this section so that restrictions apply only where the property is not in a rent control area. It also modifies Section 19 of the 2016 Act so that where the property is not in a rent control area, the rent payable may not be increased during the first 12 months of the tenancy, except in such circumstances as may be specified by Scottish ministers in regulations. So, how did the local authority obtain information? How did they collect the data in relation to this? And if we just move on to the next slide, please. There are powers on local authorities in terms of the bill to seek information, and they're set out in sections 15 to 18 of the bill as currently drafted. So the power to seek information confers a power on local authorities to ask landlords who are included in a local authority landlord register for information about any house that is entered into the landlord's entry in the register. There's also the ability for the local authority to ask tenants, and that's section 15.3 of the bill, and it confers a power on local authority to obtain information from tenants of houses that are also registered on the landlord register. If a local authority seeks information from a landlord under section 15 and the landlord fails to provide that information within a period of 28 days, then the local authority can apply to the first tier tribunal for an order for the landlord to pay a fine in the sum of £1,000. And also, if the landlord provides false information to the local authority, then they can ask for a penalty of the same sum from the tribunal. The types of information that local authorities should be gathering under these powers in terms of section 15 of the bill is information that's set out in the slide. So the address of the house, the description of the type of tenancy, the amount of rent that's payable, the date when the rent's payable, the date when the rent was last increased and by which amount, the size of the house, including number of bedrooms, the number of stories in the house and the floor area, and the type of house. Is it detached? Is it semi-detached, terraced, or flatted? The local authority can apply to the tribunal within 12 months of the landlord receiving the local authority's request for information when we're looking at the penalty provisions. Before applying to the tribunal, though, for an order against the landlord has to give the tenant 28 days notice of the local authority's intention to apply to the tribunal to give them an opportunity to request a review. And if a review is requested, then the local authority may not apply to the tribunal until that review has been exhausted and concluded. Okay, so that is a canter through the rent control areas and just a very high level overview. But if we just move away from rent controls now and have a look at the other parts of the Act. So, firstly, looking at delays to evictions. Evictions can happen for a wide range of reasons. It can be a change in the use of property. It can be a change in status of the landlord or the tenant. It can be poor conduct by the tenants. Rent arrears. There's a wide range of issues that can come before the tribunal and the court when considering whether or not to grant an order for eviction. There are strict legal processes that are currently in place the landlord has to follow when they're ending a tenancy, and these depend on the rules and the type of tenancy that you have. So, for example, if you're a social landlord, you have to comply with the pre-action requirements and the rules and regulations that are set down in accordance with the Housing Scotland Act 2001. And for private landlords, depending on the type of tenancy, but predominantly just looking at PRTs, you have to comply with the rules as set out within the 2016 Act. And also follow the appropriate notices and pre-action requirements for that. So what does the bill then propose to change in relation to the process for evictions? Well, what it's suggesting is that the Sheriff Court and the first tier tribunal, so if you're a social landlord, you'll tend to be in the Sheriff Court for evictions, and in the first tier tribunal if you're a private landlord. And really, at that time, they're suggesting that the court should be considering whether or not it's reasonable to delay the ending of the tenancy. Those of you that are regularly in the Sheriff Court will know that the Sheriff already has special dispensation powers in terms of the inherent rules of the court to supersede extract for a period of time to allow the tenant perhaps to find alternative accommodation or take appropriate steps to remedy the issues that are placed before the court. So this isn't a very new thing. However, it is not currently as drafted within the rules and regulations at the moment, and this bill seeks to rectify that. So what it's going to do is it's going to amend the Housing Scotland Act 2001 to place a duty on the Sheriff Court to consider a delay to the enforcement of the eviction under a Scottish secure tenancy or a short Scottish secure tenancy, except in limited circumstances. And it's also going to set out in the amendments to the 2001 Act the factors which may be considered in determining whether a delay is reasonable. It also proposes then to amend the 2016 Act, the 1998 Act, which is the Housing Scotland Act 1998, and that refers to assured tenancies and short assured tenancies, and the Rent Scotland Act 1984. And what it's going to do is place a duty on the tribunal to consider a delay to the enforcement of an eviction under a private residential tenancy, assured or short assured tenancy, and protected and statutory tenancies, except in limited circumstances, and will set out relevant factors that need to be considered in determining whether a delay is reasonable. The relevant factors are going to include potential financial hardship, potential detrimental effects to health, and potential detrimental effects to by having a disability. So examples which are contained within the explanatory guidance to the bill suggests that in circumstances where there's perhaps disruption caused by ending a tenancy for children during a period of exam results, or university students that will have a detrimental effect on the health of the tenant or a number of the tenant's household, then the courts could consider delaying the period for eviction until after a set point in time. Also, considerations around periods of religious observance and some traditional festive periods could result in a tenant or a member of the tenant's household experiencing heightened physical, emotional, or financial stresses. And the court and the tribunal can therefore consider whether ending a tenancy during or around such period might add additional stress and stresses on the tenants at that time, and therefore they may look to delay the eviction period again until past that period of time for it to take effect. Taking all of that though into account, the court and the tribunal has to make sure that they are balancing the potential impacts on the landlord in the event that the eviction is delayed. This is, as I say, this is something that they will already do, and it's already being done in practice. However, the amendments to the bill will make those particular requirements set out in the legislative framework rather than a discretionary matter for the relevant sheriff or tribunal member. So, as I mentioned, the duty applies to Scottish secure tenants. It applies to private residential tenancies. It applies to short assured tenancies and assured tenancies and certain statutory and protected tenancies. The duty does not apply on all grounds for recovery of possession, though. It doesn't apply where the tenant is not occupying the property as their only or principal home. It doesn't apply when the tenant has a relevant conviction, and it will not apply when the tenant has engaged in relevant antisocial behaviour. So that's the delays to the evictions. If we can just go on and have a look at unlawful evictions. So as I mentioned, in Scotland, tenants can only be legally evicted from their homes by order of the Sheriff Court or the tribunal. Evicting someone without obtaining such orders is a criminal offence, and in addition to a criminal prosecution, an unlawful eviction also leaves the landlord liable to pay civil damages to the occupier of the property under the relevant currently drafted legislative provisions. Current legislation as drafted sets out some mechanisms for the valuation of damages where an unlawful eviction has occurred. It's quite a cumbersome process though, and it requires a professional surveyor to take a valuation of the difference between the landlord's interest in the property with and without a sitting tenant. It's not only an expensive process, but it can also lead to a nil valuation, and really it doesn't appear to be a particularly well used or effective process in relation to ascertaining the relevant level for damages for unlawful evictions as currently drafted. And a briefing into unlawful evictions by the First Tier Tribunal for Scotland indicated that only a small number of cases have ever been taken, and the current process is not considered to provide enough protection for tenants. So, what's the proposed amendment suggesting? So, the Housing Scotland Bill suggests to make amendments to the Housing Scotland Act 1988. It's going to replace the basis for the assessment of damages for unlawful eviction with a calculation based on a multiplication of monthly rent. It's going to set minimum and maximum levels of damages that the tribunal can award at 3 times and 36 times the monthly rent, respectively. And it's going to place additional requirements on the tribunal to inform the relevant local authority and police of any order it makes awarding damages where a private landlord is found to have unlawfully evicted the tenant. And it can also place additional requirements on the court to inform the police and the regulator of any order it makes awarding damages where a social landlord is found to have unlawfully evicted a tenant. And these duties to inform will allow the relevant authorities to consider whether any further action should be taken to the landlord in relation to the unlawful eviction. So moving on to part 3 of the bill, part 3 changes certain provisions in relation to tenants' rights. Part of what I want to mention at the outset on this is that a number of these things, and it's recognised by the Scottish Government that a number of these provisions that are being brought in relation to changes to tenants' rights are already being carried out in the social housing sector. And therefore, you might hear these provisions and think, so what? I suppose a bit of the so what in relation to these provisions for the social housing sector is that where before this was being carried out just by good practice within the sector, it is now largely going to be, or it's proposed that it's going to be placed in the legislative framework that is a requirement to do. So very briefly, taking a look at pets in the first instance, and really, this is focused on the private rented sector. So for those that are working in RSLs and have a subsidiary arm, the 2016 Act currently only allows pets with explicit agreement. And it's up to the landlord whether or not they agree to having a pet. The current position on keeping pets within the social rented sector under the 2001 Act is different to that. And as I mentioned, the general practice within the social housing sector is to give permission for pets. And the landlords tend to generally acknowledge that pets are beneficial to the tenant and their family's health and well-being. So what does what does the housing bill suggest that they're going to make changes to? Well, they're going to amend the 2016 Act to insert the right to request to keep a pet, and that this request cannot be unreasonably refused, and it will be prescribed as a statutory tenancy term via regulations under the provisions within the bill. It's also going to amend the 2001 Act to include a new statutory right for social housing tenants for the right to make a request to keep a pet and for this not to be unreasonably refused. It's going to provide the Scottish ministers with the powers to prescribe reasonable reasons for refusal and reasonable conditions for approval in relation to the private rented sector. And it's also going to require Scottish ministers to consult with private tenants, landlords, and other relevant stakeholders as part of the secondary legislation process on reasonable reasons for refusal and reasonable conditions for approval within the private rented sector. And I think that's important because those of you that are working within the social housing sector and that have worked with me previously in the past, we often will have the discussion around provisions within the Act, perhaps around looking at mutual exchange and what are reasonable conditions for refusal or reasonable conditions that are placed upon any request that's been made by your landlord. So if there's some suggested guidance from the government, that would be welcomed because hopefully that will draw a line under the dubiety around what is reasonable reasons for refusal and reasonable conditions for approval, and make that quite clear and avoid any potential complaints and appeals to the decision making. The proposed amendments to the 2000, to the bill also suggest that there will be powers for the Scottish ministers to set out procedure and information required for a written request to keep pets. And it will also provide tenants under a private residential tenancy with a route of redress to the first tier tribunal for the unreasonable, if there has been, unreasonable refusal to allow the keeping of a pet or unreasonable conditions attached to the keeping of the pet. And if we can just then move on to decoration. So under the current legislative framework, private landlords are usually responsible for the decoration of a let property, and properties can be let or furnished. The exact terms on which property is let will depend on the tenancy agreement that's in place. And the 2016 Act is silent regarding decoration and personalisation of property, and landlords and tenants are free, obviously, to negotiate their own terms. But there are measures in the bill, as currently drafted, aim to give all private tenants with a PRT greater discretion to personalise their homes. And changes would allow tenants to be able to make certain minor modifications without the consent of the landlord, and these are called Category 1 changes. So, for example, that can be something like putting up pictures and posters. And it also will provide the right of tenants to request certain other modifications, and that's Category 2 modifications. For example, painting walls. These will require the consent of the landlord, but that consent cannot be unreasonably withheld. And also, in particular cases where the tenant has lived in the property for 6 months or more, the landlord cannot unreasonably refuse the application that's made by the tenant for Category 2 changes. So what's the bill proposing to do? Well, it's proposing to amend the 2016 Act. It's going to include a new term in Schedule 2 of the Act, which will be prescribed as a statutory term of a private residential tenancy, allowing the tenant to make certain changes to the let property, i.e. Category 1 changes, without the permission of the landlord. And then it's also going to make changes in the 2016 Act to include a new term in Schedule 2 of the Act, which allows tenants to request changes as Category 2 changes, and that the approval of the landlord cannot be unreasonably refused. The bill also creates a power for Scottish ministers to prescribe regulations for the types of changes under Category 1 and also Category 2. Over and above the very brief suggestions that we've been provided for Category 1 and Category 2 changes, what will constitute a Category 1 and a Category 2 change is not yet known. And again, we're at the point where the devil is in the detail, and that there will be secondary legislation which will follow the bill to provide further detail in relation to what these changes look like, and also the provisions around reasons for refusal and what those reasonable reasons may be, or conditions that are going to be attached. The bill as currently drafted will also provide tenants with a route of redress to the tribunal in relation to unreasonable refusal, so not dissimilar to that of a request for keeping of pets. One final change that I do want to talk about in relation to private residential tenancies is the issue around joint tenancies. And there's been issues in relation to joint tenancies, because since the 2016 Act came into force, landlords can't place time limits on the tenancy, and one joint tenant can no longer terminate a joint tenancy on behalf of all of the joint tenants, and that ensures that no tenant can be made homeless. However, where there's more than one person named on a tenancy and the tenancy is a joint tenant, all of those tenants are responsible for the total amount payable under the tenancy agreement, and that's joint and several liability, which we'll already know about. And if one tenant doesn't pay the share of the rent, the landlord can ask all of the tenants to pay. But because there's no specified time limit on a PRT, where one tenant seeks to end a joint tenancy, all the joint tenants must sign a notice to leave, giving the landlord at least 28 days notice in writing unless a shorter period has been agreed. And then those tenants that want to stay in the property will then have to negotiate with the landlord in relation to being able to retain the property in their joint names. Sorry, in their sole names or joint names if there was perhaps more than one tenant. Um, so the bill just looks to slightly amend that because that's not the position as it is in the social housing sector. There are provisions where a single joint tenant can terminate their interest in the joint tenancy, and the tenancy will automatically then convert to a sole tenancy. So the proposed changes in the housing bill are looking to align the PRTs with the social housing sector. And it'll amend the 2016 Act to allow one joint tenant to be able to terminate a joint tenancy without the agreement of all of the other tenants. It will require a departing tenant to give 2 months' notice. Again, very similar to the social housing sector, to all their other joint tenants of intention to serve a notice to terminate on the landlord, and it will prescribe certain regulations of the form and manner of the 2 month notice period. So there's really that we're now getting into the provisions of the bill where they're looking to kind of rectify some issues that they're seeing within the sector, and to try and align that over, as I mentioned at the beginning, that kind of overarching premise of the government and policy statement to ensure that there's kind of a neutrality across the tenures. So that's what they're looking to do here with this provision. Another provision within the bill, and it's just on the next slide, please, which has been picked up because of an issue that came to light after the rent cap was lifted in social tenancies. And those of you that work within the social housing sector will recall that when the rent cap was lifted for social tenancies, it was done at a time where generally social landlords would be looking to consider what the rent increases are going to be for the following year and reserving rent increase notices. Understandably, after a time where there had been emergency legislation placing a hold on rent increases in the sector looked to the legislation to ensure that the rent increases were properly served and done so in a way that complied with the legislation as currently drafted. What came to light as a result of that is that notices in terms of the Housing Scotland Act 2001 had to be served in a certain manner. It had to be either recorded delivery or alternatively it had to be delivered to the person in the tenant in person or left at the tenant's address. And practically what that meant was you were sending out thousands of rent increase notices to tenants, and it either had to be by recorded delivery or alternatively it had to be hand delivered. And if you didn't do either of those things, you were technically not complying with the Act. And in light of that, arguably, your rent increases wouldn't necessarily be able to take effect. So, quite rightly, stakeholders within the sector raised concerns about this to the Scottish Government and raised issues in relation to the current prescribed methods of delivery of notices. And so the bill seeks to include Section 39, which tries to rectify those issues and bring the current provisions for service of notices into line with what modern technology that we're using now and the way that things are being done now, rather than how it was perhaps done when it was drafted 23 years ago or more than that, probably when the Act was drafted. So the provisions within the bill include amending the 2001 Act to make changes on how notices and documents may be given in connection with Scottish secure tenancies. They make it clear that when we're talking about postal service, the postal service needs to be recorded, and that includes a way that does not require a signature on delivery. So it doesn't need to be by recorded delivery anymore, which will obviously bounce, but it can be by a tracked mail service. Or alternatively, if you can agree with the tenant in writing that all notices will be served by email, then you can serve your notices by email to the tenants. So looking at that practically, what you might be looking to do is for all new tenants going forward at sign up having some form of agreement with the tenant to the effect that any notices, including rent increase notices, can be served by email, which will make sure that you're then complying with the new provisions of service of notices as amended by the new housing bill. So just moving on very quickly, I'm conscious of time, so we'll move on quickly to the ask and act duty and then to some domestic abuse provisions. So the ask and act duty are set out within part 4 of the act. Sorry, part 5 of the bill. And it introduces an ask and act duty, and it creates a shared public responsibility to prevent homelessness. That's the aim. Relevant bodies who are listed within the bill are required to ask about housing and to help take action to help individuals and families avoid becoming homeless and going through the trauma and disruption that homelessness will bring. The bill adds to existing duties and obligations to inquire of current and prospective tenants if there is a potential for homelessness. And if it transpires that an individual is homeless, the landlord must ask whether the individuals are aware of any homelessness application being made by the individual and whether the individual consents to a homeless application being made if it is considered to be appropriate. So what's the bill going to do? Well, it's going to modify the Housing Scotland Act 1987, which has the current homelessness duties contained therein. And it's going to modify provisions in the 1987 Act to the effect that an application can be made to a local authority for homelessness by a relevant body in respect of a person. I'll come on to who those relevant bodies are, in order to secure accommodation or assistance. And any such application has to be made in accordance with the new provisions as set out within the housing bill. It is also modifying section 32 of the 1987 Act to the effect that where a local authority is satisfied that an applicant is threatened with homelessness unintentionally, then the local authority has to take steps to remove, or where possible, if you can't remove it, to minimise the threat of homelessness and to secure that accommodation is available for occupation by the applicant. It will include a new subsection to the homelessness duties to the effect the local authority must take reasonable steps to secure that the accommodation is occupied by the applicant when the application is made and continues to be available for occupation. And only if that occupation will no longer continue to be available, that other accommodation will be made available to the applicant. And if the local authority is required to give the applicant advice and assistance, then that such types of advice and assistance is going to be prescribed. So that's the duty to ask. What about the duty to act? Well, once the duty to ask has been discharged, the local authority then has an obligation to act by making the homelessness application by making the accommodation available to the applicant. If the person is homeless and an application is made under Section 28 of the 1987 Act, then in order to remove the risk of homelessness, you have to provide that accommodation. You need to minimise that threat, providing the support, as I've mentioned, and also you need to obtain the relevant consent as required. Just taking a look then at the relevant bodies. The relevant bodies are a health board, they are an integrated joint board, they are the local authority, the police, a registered social landlord, Scottish ministers insofar as they relate to the functions regarding prisoners and young offenders and persons that are detained within them, and also a special health board. So just briefly touching on domestic abuse, because I do think it's important, and I want to just touch upon it very briefly. Domestic abuse, as we know, has been at the forefront of the political agenda in housing for quite a wee while. Um, it is one of the leading causes of women's homelessness and consequently affects a significant number of children and their long-term outcomes. In 2019, the Scottish Government set up a working group co-chaired by the Chartered Institute of Housing and Scottish Women's Aid to consider how Scotland can improve the housing outcomes for women and children that are experiencing domestic abuse. And that included those experiencing financial abuse to remain in their home. There were a number of recommendations provided in the report that was produced as a result of that working group, and that was published in December 2020. And one of those was to introduce a new statutory pre-action requirement for social landlords to ensure that they have fully considered domestic abuse before commencing legal action to recover possession of a property. Um, Taking a step back from that, and I'll talk about that in just a second, social landlords must, in relation to all houses held for by housing purposes, ensure that when selecting tenants, a reasonable preference is given to certain persons. And that includes those who are homeless, who are threatened with homelessness, and also now there'll be provisions that preference should be given to those who are at risk of domestic abuse. When allocating social housing, the landlord can't take any account of the ownership or value of heritable property owned by the applicant if that person um, residing within that property will lead to their abuse. And um, really, it has to be taken into account when you're looking at your allocations policy to ensure that anybody that is suffering or experiencing domestic abuse is not going to be detrimentally affected by the allocations policy as currently drafted. And the meaning of domestic abuse has been extended to include domestic abuse by a partner or an ex-partner within the meaning of Section 2 of the Domestic Abuse Protection Scotland Act 2021. And Section 43(2) of the bill modifies the current drafted legislation to show that there are concerns around domestic abuse that it has to be probable that the occupation of the property that they're currently living in will lead to abuse. So that is something that just has to be taken into account by landlords when they're providing accommodation to those that are suffering or experiencing domestic abuse. There are also amendments to the pre-action requirements. As mentioned earlier, pre-action requirements are a legislative step that has to be taken when you're looking to recover possession of the property. Pre-action requirements are taken in attempts to resolve rent arrears with a tenant before seeking action to evict. Social landlords have to satisfy the court that pre-action requirements have been complied with before court action is taken. And the pre-action requirements as currently drafted do not currently require specific consideration of the effect of domestic abuse on the accrual of rent arrears. So what the bill proposes to do is to introduce an additional pre-action requirement where domestic abuse is a factor in rent arrears, and where the landlord considers that the tenant has expressed or is experiencing domestic abuse which is having an impact on the accrual of rent arrears, a duty will be placed on the social landlord to take such action as necessary to support the needs of the tenant, having regard to its domestic abuse policy, and provide the tenant with details of other support that may be available. Landlords, social landlords also have to prepare and publish a domestic abuse policy, and each local authority and registered social landlord will need to do that. Policy will set out how the social landlord will exercise its functions in relation to the needs of tenants who the landlord has reason to believe has experienced or is experiencing or is at risk of experiencing abuse with a view to preventing homelessness. The policy must include a description of the action that the landlord will take in such circumstances, and that is, as is mentioned in Section 14A of the 2001 Act, and 14A relates to the pre-action requirements. So that will be another duty that will be placed on social landlords in terms of the bill as currently drafted. Appreciate that we're now over time. Just very briefly to wrap up, A lot of the devil is in the detail in this. There's a lot of secondary legislation that will need to come in order to support a lot of the proposed amendments. There's quite a lot of changes that are within the bill. There's a lot to get through in it. So I suppose it's a little bit of watch this space, and we will keep blogging and releasing articles if where we think it's appropriate to do so. The amendment stage will be interesting at stage two, and then we'll get a view and a flavour of where the government is going to go from there. So with that in mind, I'm not going to take any live questions. If you do have questions, then we will come back to you after the event today, and I will pick up with you separately on that. All that remains for me to say, rather than cutting any more into your time, is to say thank you very much for joining me today on what was quite a dense subject. And we do hope that you've enjoyed it. Please feel free to get in touch if you have any questions. Thank you very much for joining, and we hope you enjoy the rest of your day.